Good morning. Good morning. Thank you guys for coming out. I am Rochelle Johnson, and I'm with Texas Department of Insurance, Division of Workers' Comp. I've been with the agency for 17 years. I am now the regional manager for the entire Houston, all the way to Lufkin, Beaumont, and so on. And I'm here today to talk about workers' comp in extent. I've been doing this for about 5 years now, traveling throughout the state talking about workers' comp. And it is a real broad subject. And so I know I'm just going to touch on the basics, but feel free if you have any questions, feel free to stop me and we'll talk more in depth about it. So let's go ahead and get started. Today, I'm going to be talking about the workers' compensation system in itself, along with injured employees' rights and responsibilities. I'm also going to talk about some statistics in regards to return to work. I will go in detail in regards to benefits, medical and income benefits throughout the workers' compensation process. And I'll talk about the dispute resolution. And we'll also cover complaints versus disputes. Because we are a regulatory agency, we do take complaints to make sure that parties are doing what they're supposed to be doing in regards to the law. And so there's a difference between the dispute process versus the complaint. So I'll go in detail to highlight the differences. Any questions so far? Okay. So workers' compensation is a state-regulated insurance program for injured employees. It does pay medical bills and some lost wages to injured employees or their beneficiaries. Now, in the state of Texas, it is not mandatory to have workers' compensation. So there are some entities like government entities who we work for, school districts and things like that. It is mandatory to have workers' compensation. But overall, it's not mandatory for employers to have workers' compensation. Now, in the workers' compensation program, it takes at least 3 participants to make the system work. The employer, who pays the premium to the insurance carrier, and the insurance carrier is the one who pays the benefits to the injured employees or their beneficiaries. In the workers' compensation system, injured employees have certain rights. One of the first ones, it's a little confusing to some people when I give this presentation because they say, injured employees say, oh, I have a right to sue my employer. Well, if they don't have workers' comp insurance, employers open themselves up to be sued. However, if employers do have workers' compensation, then they would just go through the process because they have a policy in place for them. One of the rights of an injured employee is to seek assistance from Office of Injured Employee Counsel. It is a free service. They have a right to that service, and I'm sure Yolanda is going to talk more about that agency. Office of Injured Employee Counsel is a sister agency to the Division of Workers' Comp. We do work together. However, they're more of an advocate for the injured employee, whereas Division of Workers' Compensation is the regulatory agency. Injured employees have a right to receive income benefits for which they meet the criteria. And I'm going to talk more about that eligibility criteria later on in the presentation. They have a right to receive reasonable and necessary medical care. But the key to it is it has to be work-related. Okay? It has to happen in the course and scope of employment. Any questions so far? Questions? Okay. Injured employees have a right to judicial review of disputed claims, and what that means is that the division has the highest level is the appeals panel that you can go and you can go as far up as the appeals panel in order to dispute a claim. Once it reaches that level, we no longer have jurisdiction, so they would have to go through judicial court, and I'll talk more about that later. Injured employees also have a right to hire an attorney at any given time. They have a right to confidentiality, and confidentiality is very important in the workers' compensation program. So Usually what I tell injured employees is that if they're going to have someone speak on their behalf and they call the division, they have to make sure that they're on the line in order to give permission for us to speak to them in regards to their claim. However, if they want someone to assist them on a regular basis, they should send in a letter and letting us know that they want this person to assist them. Now, go ahead.
Is there a specific form the division requires, or what would be the content of the letter?
The content of the letter would be, I, Rochelle Johnson, give permission to Amanda Sapp to, represent, or no, not represent, or assist me with my claim and give them right to receive information about my workers' compensation claim. Just a general letter. Okay. Now, in the workers' compensation system, injured employees do have the right to initial choice of treating doctor. Now, there's two different types of claims. There is a non-network claim in which injured employees can treat with any doctor as long as that doctor is licensed and hasn't been disciplined by the Division of Workers' Comp. Now, network is a little different. Network is the injured employee would have to treat with a doctor within the employer's healthcare network program. And what that means is that they can only treat with doctors within that network that the employer has. Even if they are referred out to a specialist, they still would have to treat with that network doctor. And we'll talk more about the network treatment. So, employees have responsibilities. Injured employees have 30 days to report it to their employer. They have 30 days to report that they sustained an injury to their employer. Now, if it's an illness, they have 30 days from the date they realize that they're suffering from an illness. The Division of Workers' Comp does require that injured employees complete what we call a DWC 41. And I'm going to talk more about that form. But they have 1 year from the date of injury to submit that form. It is very important for injured employees to tell the insurance carrier and the Division of Workers' Comp when their employment changes. As well as is important for the injured employee to explain or to give the doctor all details about their workers' compensation injury. And the reason why I say that is a lot of injured employees, when they get hurt, they feel like they've, hurt many or several different body parts. And the compensable injury is what the carrier has accepted as their injury. So just because they're naming all these body parts that are hurt doesn't mean that the carrier is going to accept it. So the thing is they have to really be in touch with their doctor to explain, what the injury is. And the doctor is the most vital, important person in the workers' compensation, I believe, because they have to explain to the carrier through medical reports how the injury, what body parts are injured and how they are related to the injury. And so that's what the carrier pays based on the medical that's presented to the carrier. So I encourage injured employees always to explain what their injury is, what they believe their injury is, and let the doctor explain to the carrier what those body parts are. And it's up to the carrier to accept it. Tell the Division of Workers' Comp and the insurance carrier how to contact you. I think that's very important because if dispute arises on your claim, the Division of Workers' Comp wouldn't have any way of getting in touch with you. And since the carrier is responsible for benefits, then it's very important that they know how to contact you. Now, the Division of Workers' Compensation does require that the employers complete a DWC-1 if the injured employee misses at least 1 day of work. Injured employees, injury results in the absence of 1 or more days, then the employer should complete a DWC-1. Now, the DWC-1 is the notice of injury, and it reports the injury to the insurance company. So the employer has 8 days to report this to the carrier. So make sure that as an employer, if you have an employee that's out for 1 or more days, then you really do need to complete this DWC-1. Any questions about the DWC-1? Okay, so brings you to the Division of Workers' Compensation 41, which we talked about just a few minutes ago. And what I want to point out is that the DWC 41 does establish a claim with the Division of Workers' Comp on file, and it is required for injured employees to complete this DWC 41. It is the employee's claim for compensation of a work-related injury or occupational disease, and so it is their version of what happened. The injured employee can complete it, as well as someone filing on his behalf or his or her behalf. Now let's talk a little bit about return to work. And of course, it has to be reported within 1 year. So returning to work is the ultimate goal of the workers' compensation program. Return to work, we have done some statistics on it, and what we found is that injured employees recover faster and better once they're returned back to work. They retain their benefits and earn wages, because remember, workers' comp is not 100%. They're only earning 70% of what they're used to making. They retain their job skills and prevent deconditioning, and they maintain their financial status, because remember, their bills are not going to change. It's still going to be the same, right? And so in order to maintain their financial status, it's always better to return to work and earn wages. They avoid secondary complications, and I hear a lot of injured employees say once they get back to work and they're moving, they forget about even they have to take their medication. So they need less medication and medical treatment. We have found that to be true. So in the workers' compensation program, it's important for parties to talk to one another and communicate with one another. It makes a successful return to work. Injured employees need to contact their employer, so their employer will know when they'll be coming back. It's important for the employer to talk to the treating doctor so they can understand their work status and maybe the time frame of when they can return back to work. And it's important for the healthcare provider to contact and discuss medical treatment with the carrier, so the carrier can be aware of how much treatment is needed, and since they're paying for it as well. And the insurance carrier should always be in contact with the injured employee, letting them know the status of their workers' compensation claim. So we're going to talk about benefits. In the workers' compensation program, there are two things that have to take place in order for benefits to be paid. The injured employee must have suffered from illness or injured in the course and scope of employment, and the employer must have workers' compensation. Now we're going to talk a little bit about the presumption. Chapter 607 of the Government Code was first added by the Senate Bill 310 in 2005. The bill took effect on September the 1st of 2005 and applies to any workers' compensation claims brought on or after that date. So Chapter 607 creates a statutory presumption for firefighters and emergency medical technicians that certain occupational disease or work-related if the person can prove that the disease was caused by exposure in the line of duty. And some of these diseases are listed above, and it applies to first responders. Now, Yolanda's going to talk more about that in her presentation. So let's go right into the type of benefits. There are two types of benefits in the workers' compensation program. There is income benefits, which replaces a portion of the injured employees' wages that are lost, and then it's medical benefits that are reasonable, necessary medical care. And I get a lot of questions about what's reasonable and necessary medical care. And what I found through talking to insurance companies and talking to doctors is that the insurance carriers bases reasonable and necessary a little bit something like this. If it's just a regular sprain, is it reasonable to have a surgery on a sprain? No, it's not reasonable to have a surgery. Is it reasonable maybe to take Tylenol and wrap the sprain up? That's reasonable. So the carrier basically looks at what's reasonable and necessary medical care. Any questions about that? Does that make a little more sense in regards to that? Employers, workers' compensation carriers pay medical benefits directly to the healthcare provider. So if injured employees are seeing medical bills, there's something wrong with their claim, and they need to give the Division of Workers' Compensation a call so we can assist them with trying to resolve that issue. And like I said, the ultimate goal here is for injured employees to heal and return to work. So, brings us to average weekly wage. Average weekly wage are used to calculate the amount of income benefits that the injured employee receives. It's based on 13 weeks prior to the injury. Nothing else, nothing more, just 13 weeks prior to the date of injury. However, it does include fringe benefits such as if they pay for health insurance out of their check, that will be included. The average weekly wage is reported by the employer on a wage statement, which is a DWC-3, and we're going to talk more about that. Now, multiple employment is considered. So what that means is if the injured employee has two jobs, job A and job B, and he gets hurt on job A, and it prevents him from going to job B, then he can submit 13 weeks prior to the injury on job B and have it combined for his average weekly wage. So the DWC-3, this is the wage statement which the employer is responsible for completing. The employer will fill this out and send it directly to the insurance carrier. They have 30 days from the date they were notified to report it to the carrier. And so they will fill out in this section here, employee status and time of injury, and it goes in detail. So you can kind of look at the DWC-3. If you have any questions, I can assist you with it. They also have to complete section 2, which is same and similar. And what that means is that if you have an employee that has not worked 13 weeks prior to the injury, you can take an employee that has the same and similar as the employee that was hurt and use that, and use those wages in order to report it to the carrier. Now, on the DWC-3, they have to report all wages. They have to report pecuniary wages and non-pecuniary wages. Now, pecuniary wages are monetary wages that are paid to the employee like their paycheck. Now, non-pecuniary wages are a benefit like health insurance, laundry, cleaning, uniforms, or a company car. And so that was reported right there where it says pecuniary wages, and then the other section, non-pecuniary wages. So remember, on the DWC-3, you have to include the employee's name, the address, the social security number, the date they were hired, the date of the injury, the employer's name, address, their FIN number, the employment status, the name of the filer, and the wage information, and then you sign it to certify that the information is true. Okay? And it just kind of goes through the different sections there. Okay? Now, we also have a DWC-6, which is the supplementary report of injury, and it's reported directly to the insurance carrier when wages changes. Anytime employment status changes, Say, for instance, the injured employee is now returned to work but has restrictions, then that information should be reported. Lost time due to injury, employees returning to work, or lost time after returning to work. So it doesn't necessarily mean injured employees go right out after they sustain an injury. Some continue to work and then maybe later on they go out. And so that information needs to be reported. And it has to be reported within 10 days of the changes. Lost time return to work, which is additional lost time, meaning that they were taken off and then they went back to work and then they were taken off again. You have to report it within 3 days. Okay? So in the workers' compensation program, there are different types of income benefits. The first type of income benefits is temporary income benefits, which is based on disability, meaning that the injured employee is off from work due to the injury. Temporary income benefits are paid on a weekly basis, and they equal up to 70% of the average weekly wage. Temporary income benefits is based on the medical, the doctor taking them off from work and stating why the injury prevents them from working. And that's completed on a DWC 73, which is a work status report. Now, when temporary income benefits end, it can end 2 ways. It can end with the treating doctor or a doctor returning them to work, or it can end when the injured employee has reached what we call maximum medical improvement. Maximum medical improvement is basically where the doctor says the injury is the best that it's going to get. Not all injured employees are going to get back to 100%. Some injured employees never get back to 100%. But maximum medical improvement is the point where the injury is the best that it's going to get. Now, temporary income benefits, the longest that an injured employee can collect temporary income benefits is up to 104 weeks, which averages out to 2 years. Now, that doesn't mean every injured employee will go up to 104 weeks, because remember we talked about that sprain. That sprain will not take an injured employee 2 years to heal, we hope, right? But 104 weeks is the maximum that an injured employee can be out on temporary income benefits. Now, the next type of benefits is impairment income benefits, and it's different. You can return to work and receive impairment income benefits. They are paid based on the permanent damage that has been done because of the injury. Injured employees that are eligible for impairment income benefits will receive an impairment rating of 1% or more, okay? And impairment income benefits are also paid weekly, and they're paid at 70% of your average weekly wage. However, the way they work is based on the point of percentage of impairment that the doctor gives them. They're paid 3 weeks time each point of percentage. So say, for instance, if an injured employee received a 10% impairment rating, meaning that 10% of their whole body is impaired, they would get 10% times 3 weeks, which would give them 30 weeks of pay. And that will start the day after they reach maximum medical improvement. So temporary income benefits will end. The next day of maximum medical improvement, you'll be paid 30 weeks from that day. Any questions about impairment income benefits? Now, supplemental income benefits are entitled to, supplemental income benefits are based on a quarterly basis. So what that means is the Division of Workers' Compensation will approve the first quarter, will make the determination for the first quarter, and then all subsequent quarters after that are approved by the insurance carrier. Now, this benefit is paid a little different. It's paid on 80% of the average weekly wage, and it's paid on a monthly basis. Now, supplemental income benefits are for more serious injuries, which require injured employees to have at least a 15% or higher impairment rating. One of the criteria for getting supplemental income benefits is that the injured employee cannot take impairment income benefits in a lump sum. If they take it in a lump sum, then they knock themselves out for applying for supplemental income benefits. With supplemental income benefits, the doctor can say that you're totally unable to work. You have no inability to work. If so, the injured employee will need medical from their doctor to explain that they're unable to work in any capacity, and why the injury prevents them from working. Now, if they do have some workability, meaning they have some restrictions, they would need to find jobs or look for jobs within those restrictions. Say, for instance, if the doctor says, you can go back to work, but you have a lifting restrictions of 20 pounds, okay? So if you go looking for a job at FedEx, that would not be a good search for supplemental income benefits, because that's out of your restrictions. And so you wouldn't go look for a job at FedEx, because that's not a good faith effort of trying to qualify for supplemental income benefits. And the injured employees also have to enroll in a vocational rehabilitation program. It is offered by Texas Workforce Commission under the branch of Disability Assistive Rehabilitation Program Services, which is DARS. Now, some injured employees are qualified to receive lifetime income benefits. Lifetime income benefits are just what they say. They pay for a lifetime. They can be paid weekly, monthly, or by annuity. It is paid at 75% of average weekly wage, and injured employees are privileged to receive a cost of living of 3% every year. Now, brings me to death benefits. Death benefits replace a portion of lost family income. They are paid weekly, monthly, or by annuity, and it's paid at 75% as well of the average weekly wage, and it's distributed among eligible beneficiaries. And some of them may include a surviving spouse, children under the age of 18, children under the age of 25 that are attending an accredited educational institution full-time, or dependent grandchildren may qualify for death benefits. They also have burial benefits. It's paid to the person who incurred the expense. So if there's a spouse or someone that paid for the burial, they may be entitled to receive burial benefits. Dates of injury on or after September the 1st of 2005 may receive up to $10,000. And then dates of injury prior to September the 1st of 2005 may receive up to $6,000 in death benefits. So there is a cap on workers' compensation income benefits. The longest an injured employee can receive income benefits is up to 8 years, which averages out to 401 weeks. So after that, injured employees are not privy to receive income benefits. And it's 401 weeks from the date of injury. Now, medical benefits. We talked about reasonable and necessary medical treatment, and remember, it has to be for the compensable injury. If the injured employee is being treated for other body parts, the carrier may not be related. If the carrier is denying and the doctor is stating that it is related, he needs to send a what we call a medical necessity letter or a causation letter to the insurance carrier explaining how those body parts are a part of the injury. And then at that time, it's up to the carrier if they want to accept it or deny it. If they accept it, they'll go ahead and pay for the medical treatment. If they deny it, you may end up in a dispute in regards to it. So a doctor, a healthcare provider may not bill an injured employee for a work-related injury or illness. And we talked about that. Injured employees should not be getting bills. And if they are, there is a problem, and they need to give the division a call so we can try to find out what's going on that claim. So medical treatment, reasonable and necessary, is based on the official disability guidelines, which is a community of doctors that have got together and put together the official disability guideline, which is the standard of medical treatment. And so that is what doctors go by as far as treating injured employees. Of course, if injured employees, everybody doesn't heal the same. Okay, so some injured employees may need more treatment than what the standard states, but it will be up to the doctor to explain to the carrier why he needs to treat outside of those official disability guidelines. So dispute resolution process. We have informal dispute resolution. We also have a benefit review conference, contested case hearing, and remember I talked about the appeals panel, which is the highest level in the division, and then after that you would have to go to judicial court. So in the informal dispute resolution, before I get into that, I kind of want to touch on the DWC 32 because it is a way to resolve disputes. The DWC 32 is a request, DWC 32 form is a request for the designated doctor exam. A designated doctor is a doctor that is appointed by the division. Unbiased doctor that, I'm sorry?
They have the form, but DWC 32 is in the packet that if they want to look at it.
Okay, the DWC 32 is in your packet. If you want to go ahead and pull it out, and I'll kind of touch on it briefly. But the DWC 32 is a request for the designated doctor examination. This doctor is used to resolve disputes or disagreements between parties. Some of the things that the doctor will address is a dispute for maximum medical improvement, impairment, extent of injury, disability, return to work, and return to work doing supplemental income benefits. On this DWC 32, it is important that you complete the form. If you need assistance, you can give us a call and we're able to assist you with trying to complete this form. One of the things that I want to point out is that this should be sent directly to the division. There is a fax number on the front of the form. The injured employee or the insurance carrier or the injured employee's representative can complete this form and submit it directly to the Division of Workers' Comp. What happens once that form is approved, a doctor will be selected and asked to address whatever issues that have been approved. He won't be able to address any other issues outside of that. Only the issues that he's requested are approved to examine. Of course, parties can dispute the findings of the designated doctor by requesting a benefit review conference or requesting a letter of clarification. Are there any questions about this process? Because I know we do get a lot of calls about the designated doctor. No questions? So the dispute, the Division of Workers' Compensation, when a dispute arises, the Division of Workers' Compensation is there to assist all participants in regards to a dispute. Most of the time, injured employees will request a benefit review conference, or carriers will request a benefit review conference. What we do ask is that they do try to make a good faith effort to try to resolve it before requesting a benefit review conference. That could be a phone call to the carrier asking them what they need. Maybe they just need a medical letter explaining compensability or disability. But remember, if you're going through the dispute resolution process, you have to have supporting documentations in order to support the workers' compensation injury. So the first type of dispute resolution is informal, which is a benefit review conference. A benefit review conference is an informal designed to mediate and try to resolve disputes. So what we do is we bring parties together and we try to mediate an agreement between the parties. The injured employees get up to 2 chances to try to resolve these issues. We have a benefit review officer, which is an impartial individual that's trained to try to get the parties to come into agreement. Now, it's up to the benefit review officer if they want to go ahead and send it up to a contested case hearing after the first one. But what they will do, they have an option of having a scheduling order. A scheduling order is when a benefit review conference will say to party, the insurance carrier, okay, if you do A, B, and C, and we come back to the second benefit review conference, we may be able to resolve it. And so it is an order that is given by the benefit review officer to do A, B, and C. And then if they come back to that second party, hopefully they can agree. But remember, they only get 2 chances to try to resolve it at that level. If it doesn't work there, the next level would be a contested case hearing, which is a more formal hearing. And it is presided by an administrative law judge who will issue a written decision that's legal binding. However, it can be appealed on each disputed issue. So the appeals panel, if it's not resolved at the contested case level, the appeals panel is consisted of 3 judges. The injured employee or the parties do not have to go there. All the information that was taken in the contested case hearing will be forwarded to the appeals panel. 3 judges that will preside over that information, and then they would decide if the administrative law judge's decision becomes final. They can reverse the decision, or they can remand it, have them do it all over again, or do a combination of that. So if it doesn't work at the contested case hearing level, they would have to go to judicial court, which is filed in the county where they live. The Division of Workers' Compensation will be served as the opposing party, and the judicial court has to take in consideration the appeals panel's final decision. So in the workers' compensation system, there are some required attendance that is required by the Division of Workers' Compensation. One of them would be the designated doctor examination. I mean, if we're going to appoint a doctor to try to resolve disputes between 2 parties, then the injured employee is required to attend that designated doctor. It is an order. The required medical examination is the insurance carrier's right to examine the injured employee every 180 days. Now, I know in the beginning, if the carrier sends them a letter asking them to go to their doctor, at that time, they don't have to agree to go. So what the carrier would do would turn around and complete what we call a DWC-22 form requesting us to order them to go. And if we check everything out and everything's good, then we will issue an order for them to attend the required medical examination. And it is an order for the injured employee to attend that, as well as benefit review conference and contested case hearings. I mean, because remember, we're taking up taxpayers' money, and we're also having the attorneys and the injured employee. Everybody needs to be there in order to try to resolve it. Now, because we are a regulatory agency, we do take in complaints. Complaint is a written submission to the Division of Workers' Compensation stating that a party or participant has allegedly violated an act or rule of the Division of Workers' Comp. Some examples of that, and look at the number 1, is healthcare provider who bills an injured employee for the compensable injury. An injured employee not attending a required medical examination, the insurance carrier not submitting medical records on time. And remember when I talked about income benefits, I said they're paid weekly. Insurance carriers are responsible for sending those checks out on a weekly basis. And if that's not done, that is a violation of the law. So there's a difference between disputes and complaints. Disputes are disagreements between parties, whereas complaints are allegedly violations of the law. Now, with the complaint, it doesn't have to just be a written. We also have a complaint form, which is a DWC 154 that can be completed. But you need to know the difference between a dispute and a complaint, since we wear those 2 different hats. Now, in a dispute, it's a denial of a claim. It can be the insurance carrier denying disability. It could be the injured employee disagreeing with maximum medical improvement or the impairment rating they received. It could be the carrier denying medical necessity or pre-authorization for surgery. It could be the carrier denying or not paying medical bills, partial medical bills for the compensable injury. Those are disputes that will go through the dispute process. Now, complaints are violations of the Division of Workers' Compensation law. So that means Payments were issued late by the carrier, that's a violation. A late report filed by a doctor. A commission ordered the doctor present certain medical records and he doesn't do it. That's a violation. Or a party being unprofessional. Insurance carrier just not communicating with the injured employee. That's considered a violation. So the role of the Division of Workers' Compensation is to commute and educate participants. We promote realistic expectations of the workers' compensation system. So say for instance, if you give us a call, we can tell you the status of a claim. We can tell you how to clarify the laws and rules as they apply to the workers' compensation claim. We can offer and facilitation for a benefit review conference or a contested case hearing. And in those processes, we gather and share information to identify what those issues are and try to get those addressed. Okay? Any questions? So what I encourage participants that are in the workers' compensation program is to communicate. Keep in contact with their employer and the adjuster. Talk to their doctors about the medical treatment. Remember, the medical treatment is the most important part of the claim because that's what the carrier pays income and medical benefits. It's based on the medical. So it's important for the injured employee to report everything that's going on with them so the doctor can address it earlier. Early intervention is the best. Keep the information up to date. Keep all the Division of Workers' Compensation information and the carrier's information together because you never know. Encourage injured employees to keep it together because you never know when they're going to have to use it. And so, Office of Injured Employee Counsel, like I said, they're a sister agency. They are the advocate for the injured employee. And so I believe you may want to come up and talk more about the Office of Injured Employee Counsel.
My focus is going to be mostly on the presumption, the first responders, extent of injury versus pre-authorization. That's a hot topic. It has been for a long time. And then the 32, the DD selection, that is not going to be part of the PowerPoint because I put those together. But they are in your folder. So when we go over that, we'll go into great detail. And kids' chats, and then we'll leave the question and answers to the end. So if you have a question, write it down, and we can go over it. I just want to spend as much hands-on time with y'all as I can. So yeah, we'll leave the questions to the last. So I'm going to touch a little bit on the dispute resolution process as far as the Office of Injured Employee Counsel. We start at a case development level. So once an issue is identified, we have a case development appointment with the injured employee, at which time we obtain an analysis, case review of all the facts of the case. We obtain medical records, we do medical requests. Once that medical request is obtained, we focus on the entire claim, but the first 60 days is super important. That's what the carrier is looking at as well. But we want to see what happens. Those records tell a story from the time of the injury up to, whenever we are in contact with them and are assisting them. Once we do a review of the medical, we do a causation letter. A causation letter is required, and we do it on any issue. The only ones that we probably wouldn't is a maximum medical improvement and impairment rating because there's a process for that. They can go to their treating doctor for an alternative certification. But we send a causation letter on the issues that we identify, and that's in attempts to get the doctor on board and try to get an opinion in regards to what the dispute is, what the carrier is saying they're not accepting. Medical expert opinion is required under the workers' compensation system. There's a criteria that needs to be met on that letter from the doctor. Once we get anything in supporting of the injured employee, we exchange that with the adjuster, the insurance company, to see if we can resolve the issue prior to having to go into any kind of proceeding. If we're not able to reach resolution, then the injured employee has a right to move forward to what we call a benefit review conference. It's more of a mediation setting. It's the carrier, the injured employee, their representative or their ombudsman. We lay out the positions and we try to see if we can get it resolved. If we're not able to get it resolved, then they have a right to move forward to a contested case hearing, which is a formal proceeding where there is an administrative law judge who will be provided with the exhibits of evidence, listen to testimony, and then they'll make a decision in order in regards to the issue that they have before them. The last process is the appeal process. We do assist them through that process. It's a written appeal. The injured employees seem to think that that's going to be a whole new trial, whole new hearing. It's not. It's a written process. We assist them in writing the written appeal. That is submitted, and then the appeals panel board will review that decision in order and will review either the response or the request for review that we're assisting the injured employee with. They will mail out a decision in order to the injured employee. At that point, the injured employee, if wants to pursue, they can pursue it pro se, which they can represent themselves, or they can hire an attorney to assist them through that process at district court. But that is the last process that we're able to assist. So the overview that I've given y'all thus far is the dispute resolution process and how we interact and how we're involved with the injured employee. So I've gone over that. So we're going to talk about injury. So basically, injury is harm or damage to the physical structure of the body. Someone was working, they have to be further in the affairs of the employer at the time of injury. We have a specific injury and we have occupational disease. A specific injury is pretty general, kind of like this gentleman here who fell off the stairs and hurt every part of his body, right? Then we have occupational disease, which can also be, there's various ones, repetitive trauma. We have, people who pursue carpal tunnel syndrome from typing all day, every day, long hours of the day, butchers, cut meat every day, to cancer for the first responders. It can be another form of an occupational disease. So basically on every issue, the injured employee has the burden of proof. It lies on them. So they rely on medical expert opinions. That's why the causations are important. Those are not very easily to get always. Unfortunately, the only issue that the injured employee does not have the burden of proof on is when they have met the presumption. That means a first responder who has met the applicability under the presumption, the carrier has the burden. So that's the only type of issue where the injured employee does not have the burden is on the presumption law, chapter 607. So the burden, what's a burden? The burden is that the injured employee has to show that he or she was furthering the affairs of the employer, and as a result, they received harm and damage to the physical structure of the body, which is an injury. Some of the unique issues that we deal with is heart attacks, mental trauma, occupational disease, and repetitive trauma. These are pretty unique. I think we used to see heart attacks and stroke a lot. We haven't seen much of those. Now it's more into the cancer. That's kind of what's happening right now. So that's died down. Mental trauma, we do see that. I think 50%. What do you say, Jan? How often do you see a mental trauma injury?
I don't know that it's 50%. It's gone down in the last few years.
So we do see some of that. Occupational disease, we do see quite a few of those. Repetitive trauma as well. Some of the exceptions is intoxication, active third person, voluntary participation in a social activity, act of God, and horseplay. These can be not compensable because of the exceptions. The carrier will raise exceptions on these issues, which make it very difficult for us to prevail. So I'm going to go on to extent of injury. So, lamely speaking, an extent of injury is when the insurance company has accepted that there was an injury in the course and scope of employment, there was harm and damage to the physical structure of the body, but it limits it to certain conditions or body parts. That's as simple as I can put it. I was hurt. I hurt my shoulder, my hip, and my leg, my knee, and then I wasn't getting better. They were focusing on my hip because I had to have emergency surgery, and so they got me in there and they were focused on my hip and they forgot about my knee. Later on, I was medicated, so that medication was helping. It was helping my knee. That's my position as an injured employee, was helping my knee. I was on medications. I wasn't feeling the effects of it until after I had post-care and I was no longer receiving medication. My physical therapy was over and my knee is just killing me. Well, the carrier's saying, nope, we're not going to accept that knee. We're not going to accept it because it wasn't in the medical records within the first 2 months. All we saw was the hip, hip, hip. We didn't see anything about the knee. So that's kind of an example of that. Then that's where the ombudsman, if they're receiving assistance from OIC, would come in, and then we would, obtain all the medical records and come up with a position and point to facts on the records that we have. So mechanism of injury, super, super, super important, very important. What we see a lot of the times is that injured employees would just say, I was walking down the hall and I fell and I fell on my right side. And sometimes that's it. Sometimes they'll say, my shoulder hurt, I hurt my right shoulder. So if you have somebody who was on the 4th floor, this is why it's important. The mechanics of the injury is so important, because if you were on the 4th floor and you fell, down 20 stairs and you leave that out, that injury is not going to seem as impacting as it was. So it is super important on the mechanism of injury. I think in the mechanism of injury, that's probably the only time that we want you to be very, very detailed on. That we want you to be very specific and detailed on it, because it really tells the story of the injury itself and how dynamic it was or minor. Not that it's not important. It's important either way. If it's, a bad injury or not as bad injury. But it's super, super important that they document where they got hurt, when did they get hurt, and how did they get hurt. Again, the injured employee has the burden of proof on the extent of injury issues and the mechanism of injury, basically on extent of injury and any injury, even if they dispute the injury in its entirety. They have to have a linkage. You have to have a link of the mechanics of the injury has to be linked to the condition or the diagnosis. That is what the doctors have to tell us. They have to link the mechanics of the injury. How do the mechanics of the injury cause X, Y, and Z? And I'm sure y'all all see this. What is a condition that you usually see all the time, that all of us have? Degeneration, right? So I could say probably all of us have degeneration, but it's dormant. It doesn't cause us any problems. It doesn't cause any debilitating effects. Nothing to that. But when an injury happens, it's a big possibility that that condition got aggravated and it became alive, and you began to have symptoms, you began to have debilitating effects because of it. So I'm going into that because extent of injury, we see that all the time, even compensability at times. So the doctor will also have to show that. Not only the linkage, tell me how it became worse. Tell me how it was aggravated. Show me how it was aggravated. If there's radiology reports from before and then, prior to the injury and at the time of the injury, that's a great way of the doctor being able to say, look, I have 2 radiology reports at this time, this is what I saw, and now this is what I see. But that's also what the medical expert has to provide for us. So it varies from city to city. And we have some doctors who are on board and they're willing to help, and some just don't. And they do give us a medical expert opinion, but it's not as strong as it should be. It doesn't meet all the criteria that it should meet. So we do run into a lot of issues with that, and the injured employee does have the burden. So complex conditions require expert medical evidence. So this is just kind of an overview, the life of a workers' comp claim. You have the injury, you report it to the employer. They have 15 days to accept or deny a claim. And then they have a 60-day investigational period. After that, usually that's when we start seeing the PLN 11s, plain language notices from the carrier. The 15 days is a PLN 1. That's a PLN 1. So they can say we're going to approve or deny. And then about 60 days are on, and sometimes even earlier, we start seeing the PLN 11s. So the determination if there's a compensable injury or not, we deal with it. We may run into an extent of injury issue. And if there's any benefits, because they're not able to obtain or retain employment as a result of the injury during that time, an important thing is that they can receive temporary income benefits up to 2 years if they have the work status report to support that, or if they reach maximum medical improvement, whichever one comes first. So they're usually confused with this part of it because they feel like, I'm still getting care. I don't think I'm the best I can be. There's other things that they can do for me, that sort of thing. But if they are placed at maximum medical improvement before, then the temporary income benefits stop regardless. And then they have to go through the process of disputing that if they don't agree with it. They have 90 days to dispute it. We go through that process. And until there's either a decision in order, a DWC-24 an agreement, then that's basically on the back burner, standby until we get one of those things. And I'm not going to touch too much of this because the division's already covered this. 401 weeks. Disability doesn't start till 8th day of disability time. So it has to roll into the 8th day in order for it to start, for benefits to start. And you have to have a work status report, which is a DW-73 from the employer. So now we're going to go into income benefits. Again, I'm not going to touch a whole bunch on this because it's been covered in detail. So we have temporary income benefits, which is benefits while you're off of work due to a compensable injury. Then you have a right to get a MMI and impairment rating by a designated doctor. They will provide that on a DWC-69. They will provide an MMI day and an impairment rating. If you get an impairment rating, as discussed earlier, it's times 3, the percentage times 3, and then you get those for that many weeks. Supplemental income benefits, the only way you can qualify for that is if you get a 15% or more. Disability, discussed it already, inability to obtain or retain employment as a result of the compensable injury. Maximum medical improvement. This date is based on reasonable medical probability that further material recovery from a lasting improvement to an injury And lamely, what that means is that the doctor has done everything he can for you for that compensable injury. He's exhausted all conservative care. He's exhausted surgical for that compensable injury. And there's nothing else out there that's going to make him better. So a lot of things, what we run into in this situation is they're like, well, I've already had 3 injections and he's going to send me for 2 more. So that means that I can get better. Well, if you've had 3, the odds are probably going to be that you're probably not going to improve any more than you have already improved. So unless it's something outside of injections, like chronic pain management program or something that you have not undergone that may show improvement, then we potentially may have a good case. We will assist them regardless of what we have before us. I want to make that very clear. We will assist them regardless, and we'll do the best that we can to help them through the process. Maximum 104 weeks from the date of which income benefits begin to accrue. This is known as statutory MMI, and this date is created by the law. Statutory MMI is important because you run into situations where they've already met and they're already at statutory, and let's say that a week after statutory, they undergo surgery. Well, by law, they can't consider that. They can only consider from the date of injury up to statutory day. So when they're doing a maximum medical improvement and impairment rating evaluation, that designated doctor cannot take into account that surgery that took place because it was after statutory. Now, if it happens prior to statutory, then all that's considered from the date of injury up to statutory. So that's where we run into issues, but there's also an exception because for spinal injuries, there's a lot of deadlines and things that I'm not going to get into, but there's a form. What form is it? Shonda, do you know? Okay, so the 57 is what they use if it's a spinal injury, and it's kind of an extension because it's a spinal injury. But there's a lot of deadlines, and it's very immaculate. You have to, I always refer them to the division because they're very picky when it comes to that form and the deadlines and so forth. So that's a highlight I think that you guys should know on statutory. So we've already discussed that. Dispute resolution process. I've gone over that as well. That's basically where we identify a dispute and assist the injured employee through the dispute resolution process. Free of charge. We are licensed adjusters. We're familiar with the law and the rules. We assist, we don't represent. And we talked about the benefit review conference, contested case hearing, appeals panel. Now we're going to get into medical benefits. So, this medical benefits is a controversy because we have to distinguish, are we dealing with a medical necessity issue or are we dealing with an extent of injury issue? You have to have a doctor who has requested something, and as a result of that request, the injured employee gets denied. So I don't like the word denied because the minute anybody gets anything, I'm denied. So in reality, that's not true. It is somebody who is being prohibited to obtain or retain either indemnity or medical benefits. So if a doctor asks for a physical therapy for the left shoulder and they deny it, they say, you cannot get it because it's not within the official disability guidelines. That is a medical necessity issue. And if there's an extent of injury issue on that, and if that treatment is for, let's say they've only accepted a left shoulder sprain strain, and the doctor puts in for injections to the shoulder, for a rotator cuff tear. And the official disability guidelines, let's say the doctor supplied everything that was needed. He was in compliance with official disability guidelines. He met the entire criteria for the official disability guidelines. Even if it gets approved, that injured employee is not going to be able to get that care because it's for a condition that the insurance company has not accepted to be compensable. That's what we call an extent of injury issue. That's where you differentiate and you educate and you tell the injured employee, okay, we got to do this. Let's move forward. Let's go through this extent of injury process. Let's see if we can get this accepted. The minute we get that, then unfortunately they'll have to start the process from the beginning because those approvals have deadlines. You have to get them in a certain amount of time. So that's an example of differentiating extent of injury and versus medical necessity with all the compensable conditions. Now, if they've accepted a rotator cuff tear and they're all within the official disability guidelines, then that person is good to go. But a lot of times, that's not the case. The case is the other way around. And why waste the doctor's time, and everybody's time really, because you're not going to be able to get it, even if it's approved. Another thing that we run into is, the doctor paid for it. The doctor paid for the surgery, the doctor paid for this, the doctor paid for that. That means they accepted it. Well, unfortunately, that's not the case. Just if they chose to pay and they did it, it doesn't mean that they accepted it. And we'll talk a little bit more about that when I get to the 32s because I do have scenarios to get around that as well. So medical benefits, reasonable and necessary medical care needed to treat a work-related injury. So if you take anything from this, it's going to be, everything has to be as a result of a compensable injury. That's what it is. That's what it boils down to. It should be evidence-based medicine. The insurance carrier will pay medical benefits directly to the healthcare provider. Goal is for the employee to get better and return to work. And that is a great goal in any aspect, in any area that we're in. It doesn't matter who our employer is, what we're doing. I think that's an important message. I think it's a healthier message for the injured employees, to have a goal and to try to get what they can, the care that they can receive to try to get back to work. Although I know there's obstacles, I know that sometimes they can't get, past an obstacle because the carrier is not wanting to pay, or we can't get a causation letter, or whatever the case may be. But we should still give them a goal and help them try to reach it. So pre-authorization of health care is an employee who's entitled to all health care reasonable, required, as needed. Some health care treatments require pre-authorization. Approval is requested by the health care provider or injured employee. So like I talked earlier, extent of injury versus pre-authorization, it's kind of like a double dispute. Marcus, do we need a break or are you good on time? Okay. You really need to identify if there's an extent before we even waste the doctor's time, waste anybody's time in regards to going through the pre-auth. The best practice would be go through pre-auth if your claim is fine and they've accepted everything and everything's running smoothly. Then let's do it. Let's go forward with it. If we have an extent of injury issue, we really need to focus on the extent, get the extent resolved prior to even moving forward with pre-authorization. So this is kind of a double-sided, so you can kind of see it. Extent of injury, indemnity dispute, explanation how claimed injury was caused. Pre-authorization of health case is medical dispute, explanation why medical treatment is needed. And it's, based on the official disability guidelines. Now, we don't hear it a lot, or they really don't communicate it a lot. But the doctors can also, if they don't want to go with official disability guidelines, they can also provide a analysis, medical expert opinion, explaining how this case is specific and different, And he would have to, of course, explain how the injury and how the treatment is going to be successful. He would have to give a ratio of, I've done so many of these, and as a result of these, it's 80% that have been successful. And this is why I don't think the official disability guidelines apply. You or your private insurance company pays for medical treatment, then the injury is determined to be compensable. So we see most of this with a lot with the first responders, firefighters who have gotten cancer. A lot of them go through the care. Of course, as you know, it's major care and certain care. You have experts that you need to get care from. You're not just going to go to the ER. So a lot of times that's an area that we see where they go through the care and they pay for everything, whether it's out of pocket or the private insurance pays for it. And it's not until they're better that they want to move forward with being compensated for those expenses and the care that was received and so forth. So in order for that to happen, we have to have a decision in order, or we have to have a DWC-24, which is an agreement from the adjuster. Once that agreement is signed by all parties, it's submitted to the Division of Workers' Compensation. And I don't know who's doing those now. Who's doing the agreements? Do y'all do that by field? Okay. So the benefit review officers, I knew it changed, I just wasn't sure. So the benefit review officers now will make contact with the parties, I think, at times, and if it's approved, then they sign off on it. That will allow, that one paper will allow the provider to be reimbursed, and it will also allow the injured employee to submit a reimbursement for the out-of-pocket expenses. Do y'all have an out-of-pocket, like a form for the reimbursement, or is it, do y'all not? Okay, so the DWC-60 is for the reimbursement. That's usually when that's when I see it the most. Jan, do you have an input on when else you would maybe see out-of-pocket, or where they go through their provider and then we receive them? It's going to be occupational. Okay. But without, it's not letting me go on. Without that agreement or the decision in order, they can't. I guess I'll give you another scenario that I do see sometimes. As we're talking through education and we've gone through the process, and they're just like, you know what, I'm done with this. Like, I don't want to mess with the division. I don't want to mess with the insurance adjuster. I don't want to mess with OIC. I don't want to mess with no one. I want my private insurance to pay for it. I want to go my private. Well, the private usually won't. There are occasions, I'm not going to say they never do, because there are occasions where the private care does go, but a lot of the times they don't. They're like, we're not going to touch you. We can't do nothing with you. It's workers' comp. You're pursuing workers' comp. That is another area. That's another situation where if the carrier's telling you, the injured employee's telling you that they're done with the workers' compensation part of it and they want the provider to do it, they can ask to get an agreement stating that the compensable injury does not extend to and include whatever it is that they're battling with. Once all parties sign it, the division calls them. I know on those for sure, they call them to be sure that they, on their own, made that decision and nobody, told them to do that, advise them to do that. That's another way too. Once you get the agreement, they can go private. And that's great if that is great. I'm like, that's great if the provider is willing to see them and tweet them and stuff. Like I said, it varies, I guess, city to city, as everything does. But if that's working, hey, continue to do it. Just know that they do have a right if they really just are tired. And I see that mostly on old claims, like older claims, that initially they went through all the care, there was no problems, and then let's say 5 years later, they're having problems again with that area. it's going to be very difficult to prove on our part, because if 6 years went by, we're going to have to still show that it's a continuation of the compensable injury versus something new. You know, what did they do in those 6 years? Did they work for somebody else? Were they retired? You know, all these things go into play. So that's usually when I've seen it. And then I give them the option, you know, it's like, well, you know, you do have a right if you're just, and they're telling me I'm done with it, I just want my provider to do it. That's the only time I have a discussion. If they don't say any of that, I don't give them the option. But if they do, then I give them the option, you know, well, you can enter into an agreement, but you're going to be entering that this is not as a result of the injury, and then that's going to give the healthcare provider the okay to take care of you. And you do have those injured workers that are just done, you know, so we told you it was a DW60, talks about how to request reimbursement from the carrier. Hopefully that's not my phone. When the IE has paid for health care provided for the compensable injury. Otherwise, then of course the carrier is not liable for it. So we talked about bills earlier too. I think education to the injured employee is important here because they hold on to those too long. By the time you get them, they're already at collections. So in reality, you need to alert them. If you're getting these, the minute you get them, let us know, let the division know, they'll send a no bill letter, and they'll be notified. And they cannot get billed until there's final adjudication on the claim. That's the key thing. Until final adjudication, meaning a decision in order, and even an agreement, they can't bill. Okay, so reimbursement for certain drugs. There is a pharmacy. Certain drugs do require pre-authorization prescriptions by brand name rather than generic. The IE shall pay the difference in cost between generic and brand name drugs. The IE is not entitled to reimbursement from the carrier for the difference. What happens when your workers' compensation insurance company or employer does not dispute the compensability of your injury? And who pays for it? So I'm just gonna kind of breeze through this. It's pretty basic. They have 15 days to approve or deny. These are the things that y'all need to take with y'all. That's usually the PLN 1. So this kind of ties into this. If they don't do that within the 15 days, and let's say the injured employee got care for they didn't submit the PLN 1 until the 30th day into the claim, then the carrier is liable to pay for anything that transpired from the date of injury up to the date that the PLN 1 was filed. So that's what we call the 15-day waiver period. So if that happens, a lot of times that's one of the first things I look at when I get a claim is like, did they file it timely? Because if not, they're going to have to pay. But usually I see that as a resolution to some of the claims, because all they want is for them to pay for that initial care. Like especially firefighters who were in a fire and got exposed to smoke, they're having problems breathing. They go in, they do these tests, and they're okay. They clear them, they treat them, and they clear them. They don't want to be responsible for that bill. So I've seen it being positive in that way, that they end up having to eat that bill because they didn't file it, within the 15 days. What happens when your workers' compensation insurance company pays for medical treatment? Then injury is determined not to be compensable. We have what we call, well, we don't, but there's a subsequent injury fund where these funds go into. So the injured employee won't be responsible to pay those back. They would have to request to get those from the subsequent injury fund. Some of the benefits that get put in there is like sometimes death benefits. It's unfortunate because I would just much rather them pay the beneficiaries, but when it's found not to be in their favor, that money has to go somewhere and it goes into the subsequent injury fund. So that's one example of how the monies get in there. Not responsible for paying for it. So now we're going to talk about first responder liaison. That's me. And then we have the regionals in the office, in the field, in each field that are basically my direct point of contact that we deal with. How are y'all seeing a lot of first responders here in this area? I mean, injured employees, first responders? Is it police officers, firefighters, EMTs? What do y'all see most of? Both. So I had not had any. I just had a training Monday, and I said I haven't had any, and just because I said I haven't had any, now I have one. So I'm curious to see how many. Do y'all see a lot of EMT injuries here? What are some of those injuries?
Low back.
Okay.
Lifting and
Yeah. So in West Texas, we don't see a lot of them, but I handle the whole state. So I think this one is in Houston. I think it's in here, actually.
I'd like to think because my team does such an awesome job.
Right.
For our employees, that's why we don't see.
So, okay.
Who was it? I'm just kidding.
Oh. And it wasn't a back injury. It was MRSA. So it's going to be a good one to work with. Interesting.
Yeah, we do tell our employees, Yolanda, about the Office of Injured Employee Counsel and the First Responder Liaison. So we do give them all of that
Information.
so that
Good.
your team can help them through.
Yeah, absolutely. Public safety employee, who's a first responder, public safety employee or volunteer whose duties include responding rapidly to an emergency. Individuals employed by a political subdivision who is a police officer, EMT, licensed paramedic, firefighter, whose principal duties are firefighting and aircraft crash and rescue, or a volunteer firefighter or an emergency medical service volunteer. So I think here, usually they lose a concept, or the questions that I get are going to be volunteers. You know, they are part of this statute. I just had one, just to give you an example, who hadn't been on the payroll long and really didn't have like an average weekly wage because they do it 13 weeks prior to the injury. And the adjuster was telling them that, you know, he wasn't going to be owed any benefits because he wasn't on the payroll. And so because he didn't get paid, then he wasn't entitled to any benefits. So I'm like, no, there's got to be somebody in that fire department that worked like you worked as a volunteer, and they can use what we call same and similar wages and stuff. But it's just little things like that. You know, if they don't ever make contact and you don't know, I mean, he probably would have said, okay, well, I guess I'm not going to get paid any benefits, but it's important. Employer notification: an employer that employs first responders or supervises volunteer first responders shall notify the first responders of the first responder liaison. So you're doing your job. Discrimination is prohibited. I'm not going to read this to you because you all can read, but I think it's just like anywhere else, it's not tolerated. Just because they file a claim, you know, and you will run into those injured employees that say, you know, hey, I filed a claim, and as soon as I filed a claim, this happened, you know. But it's not, basically it's not accepted. It's not accepted.
10 minutes, and then it's just going to shut down.
10 minutes. Just kidding. Y'all have, I think she gave y'all the PowerPoint, right? So if it does shut down, we're good. So they can't do it because they file a workers' comp claim in good faith, hired a lawyer to represent the employee in a claim, instituted or caused to be instituted in good faith, testified or is about to testify in a proceeding. It's prohibited, basically. Post-traumatic stress disorder. Do y'all see much of that? Some? So do y'all see them early on in the claim, or do y'all see, okay, let me ask you this. Is it a specific event, or is it multiple events? Okay. So meets the diagnostic criteria. There's a criteria for post-traumatic syndrome, and it's specified in the APA in the DSM-5. The event occurring in the course and scope, the event was a substantial contributing factor. And there's the Texas Labor Code on that. Injury arose out of an event that occurred at a definite time, place, and the cause of it. So the issues that I usually run into is that it's multiple events, and then that last event basically triggered it. That's difficult. That's very hard for us to, because it's very specific. It's another one of those black and white, it has a criteria that needs to be met, and it has to be a time, a place, and a cause. The criteria is about to be listed here in the next slide for y'all. This should not be used to make a medical assessment. Of course, rely on the doctor, have them talk to the doctor. And, if we have the opportunity to talk to the doctor, we will as well. If presumption does not apply, the injured employee may pursue the mental trauma injury of PTSD by citing Texas Labor Code section 408.006. Here's the criteria. Exposed to death or serious injury, actual or threatened, event is persistently re-experienced, avoidance of trauma-related stimuli after the trauma, negative thoughts of feeling that began or worsened, trauma-related arousal and reactively that began or worsened after the trauma, symptoms last more than 1 month, symptoms create distress or functional impairment, symptoms are not due to medication or substance abuse. Exposure to a reportable disease. Mandatory testing after exposure. And this is kind of like what we were talking about earlier. It's always in this really too. Go to the doctor, get those tests, get that care early. Qualifying workers' comp benefits, the employee must provide the employer with a sworn affidavit that includes the date and the circumstances of the exposure. Document that no later than the 10th day after the date of exposure, the employee had a test result that indicated an absence of a reportable disease. I'm going to touch a little bit on that as far as maybe I'll wait. So expedited medical benefits applies only to a first responder who sustains a seriously bodily injury in the course and scope of employment. The first responder shall provide notice to the division and the independent review organization that the contested case hearing or appeal involves a first responder. So it's serious bodily injury. A political subdivision, DWC, and insurance carrier shall accelerate and give priority to claims for medical benefits. The division shall accelerate a contested case hearing requested by or an appeal submitted by a first responder regarding the denial of a claim for medical benefits. That's pretty self-explanatory. Surviving spouse, that's what I was going to talk about earlier when they were talking about death benefits. New that went into legislation, this past legislation, is now the spouse of a first responder can continue to get benefits, death benefits, even if they remarry. So once they remarried, they would stop the benefits. That's no longer the situation. If they're married to a first responder, regardless if they remarry, they'll continue to get death benefits. And Shauna talked about, the children and being in school and that sort of thing. She also talked about who could be eligible. There's various people who could be eligible. Various documents are necessary to substantiate that beneficiary. The presumption. Firefighters, EMTs, police officers, Chapter 607. Basically, let me get I have a handout here. Okay, so basically they have to, once the applicability is applied and they meet the entire applicability for the presumption, that's basically where they enter into, that's where the presumption protects them. So this was created in legislation in 2005. Certain first responders benefit from the presumption. Those who qualify are presumed to have suffered a disability or death in the course and scope of their employment. Who's eligible? Firefighters, EMT, police officers, and volunteers. Volunteers considered to have been employed or compensated while the individual actively served as a volunteer firefighter. And basically it's the same thing. Who is continually serving, responding, participates in a minimum of 40% of the drills conducted by the individual's department, 25% of the fire or other emergency calls received by the department during the time that the volunteer firefighter is on call. Some of the applicable diseases are smallpox, TB, cancer, and heart attacks and strokes. As I mentioned earlier, we're not seeing a lot. We see some come in, heart attacks and strokes. Are y'all seeing a lot of that here? Or not really? It's kind of died down, I think. So the burden of proof, first responder injured employee claiming the presumption applies. So this Chapter 607, they have to be employed for more than 5 years. We have to have a pre-employment medical exam. They have to respond to frequent calls. They have to be a non-tobacco user. I'm trying to think what else. And of course, they have to hold the role of, being a firefighter. Once that is met, that's what we call the applicability in Chapter 607, then the presumption protects them. And the carrier has the burden of proof. They have to show that something outside of their employment caused their condition. So let me see. And that's basically it. And even in these cases, we're going to want, a medical expert opinion. Although realistically, it's basically known that there's not a doctor that can specifically tell you 100% that, for instance, cancer came from X, Y, and Z. But we still try to get a medical expert opinion in case the carriers do argue that, and that burden can be shifted back to us. That's why it's super important to have that causation letter. If they don't meet the applicability, then it's a harder battle for us. But we will definitely, prepare them and develop it to the best that we can. So there's some things in legislation as far as the applicability, the cancer, the rebuttal, and that sort of thing. It states that if you retire and no longer employed, that's one of the areas that I've seen a lot of issues with, struggles, and it's kind of disheartening, then they can't. The presumption doesn't protect them. They can pursue it, but the presumption does not protect them because it was discovered while they were not employed anymore. So that's tough. That's a tough one. Hopefully, legislation is going to be making some changes. You know, at least, and it's just one word that really makes that happen. It's while employed, or 2 words, while employed. That's what causes kicks them out. The other thing that is difficult is the tobacco use. That also has 2 prongs in the law. And it basically says if you're furthering the disease that you're pursuing is be caused by cancer, and it says and tobacco user. So that little and, we have to meet 2 prongs. So for instance, if I'm helping somebody and they've met everything on the applicability, but they use smokeless tobacco, they dipped, right? So I could prove that here are 7 cancers that this product causes. And the cancer that I'm pursuing, it doesn't cause that cancer, right? I could prove that, but I can't prove that he was or she was a tobacco user. So because we have 2 prongs to meet, it makes it a lot more difficult for us to, and the presumption weakens.
Doesn't it extend to the spouse as well?
The smoker. The smoker part is on the spouse. So maybe that's another thing that legislation can hopefully work on, you know, because it's just that one word and, it makes it to 2 prongs instead of, if it was or, then if one was met, then we would be okay. So do y'all see much of smallpox or TB around here? I don't think we do either. Jan, have y'all had any? Yeah, the minute we say it, we're gonna get it. So just know that this is also presumption is also applies to smallpox and TB. And of course, you just have to, again, have the linkage in there. So applicable illnesses is cancer. That's one that's we're pretty busy on right now. We're getting a whole bunch of them. Are y'all getting a lot of them here? Let's see. So they're coming in a little more than anticipated. So basically, it just has to be, what it says is that cancer is known and associated with firefighting, exposure to heat, smoke, radiation, or a known carcinogen. And we rely on the IARC. It's 818 pages, International Agency for Research on Cancer. It's a lot of material. But the carrier side is that they're only accepting 3 types of cancers and nothing else. And that is not noted in the IARC. It says that primarily, it's page 575 of the IARC, and it says it's primarily prostate, testicular, and non-Hodgkin's. Yeah. But it says primarily. It doesn't say these are the only 3. But that one page, that's what they go on. They go on that if it's not those 3 cancers, then it's not related. But the thorough search of the IARC, there's many cancers that are shown to be related to shift work and being exposed to carcinogens in the IARC. This is the last part of it. So on heart attacks and strokes, I guess the thing to point out on that one is it has to have occurred in a definite time and place and occur during a specific event. You will need testimony and expert medical evidence to prove that it was caused by what you were doing for the employer. think we're at the end of it. I mean, as always, I guess, the highlight is, always work together. The more of us who work together and with the injured employees and all parties of workers' comp. Workers' comp is not a simple thing to do or to work within. So work together, ask questions, make contact, know that the Office of Injured Employees here to assist. We're here to assist, educate, and advocate on behalf of the injured employees. You have the division who handles all the regulatory agency stuff. If you think something's not going on that should be going on, or something's not right, or are they following the guidelines, better scenario is call and find out instead of not knowing. So they will give you that answer. The last thing that y'all didn't get to see up here is Kids Chance of Texas. Are y'all familiar with Kids Chance of Texas? Anybody? It's a nonprofit. It offers scholarships. It's a scholarship program for students who have had a parent either severely or fatally injured while in the course and scope of their job. And then my contact number, but there's a bio in there, and all over the folder in there, there's my name, my phone number, my direct first responder resource box, which we call resource box, is email, and the direct number. I do have an assistant. Her name is Cynthia Sanchez. So anytime I'm not in the office, she'll get back with y'all, or she'll answer the calls, or whatever the case may be in my absence. So I'm going to close it with the 32s. So I worked a couple hours with Betsy on this, and I think it's super important to know. And I think just from speaking to her, y'all had a success in seeing some improvement in this area as after our little training session. So I put a little handout together. It has a little doctor to the left of it. That's what we're going to be going over. And also the 32, because I'm going to be referencing some areas in it that are super, super important and that can really change the outcome of that designated doctor exam and the designated doctor's assessment. So frequently asked questions. What issues can a designated doctor address? Maximum medical improvement, impairment rating, extent of injury, disability as a direct result, return to work on supplemental income benefits, which is the 1 year after the second anniversary, which would be the 8th quarter of supplemental income benefits. How often can a designated doctor examination be performed? 60 days from the previous doctor examination. If it's before that, they shouldn't get approved. Do all the fields of the form need to be completed? Yes, even if they don't apply. So put in A if they do not apply, because they're super, super picky. They would deny it and send it back to you for silliness. You forgot a letter. I've seen some crazy stuff, but nevertheless, just do as you should, and then you won't run into that issue. Will TDI DWC assign a qualified doctor? Yes. Designated doctors are assigned per the applicable qualification criteria, and of course they all have to be licensed under the 4th edition AMA guides. It's not on there, but I didn't put that on there, but they have to be licensed under the 4th edition AMA guidelines. But they're selected applicable to the qualification criteria for the area of the body affected by the injury and the injured employee's diagnosis. This is what's overseen. Put a red star next to it. I don't care, a heart, whatever you want. But this is very, very important, and I'll tell you why in a minute. Where can I find more information about designated doctor process? I actually put the link to the division there on the DD process, and I also took the information that we're going to go over, a part of it, which is the DD selection area, that came from the division site. What are important designated doctor rules? So I basically applied, and all this came from the division. So I applied the rules. We'll start with 127.10, and those are just the general procedures for designated doctor examinations. So what we see a lot of times is that the injured employees will go see a doctor and they'll have a stack of medical records and they'll go to the doctor and say, here, doctor, I want you to review this before, I want you to have this. And the doctor's like, I'm not taking it. They already sent me that stuff. I don't need to see it. Well, a violation can be entered because the rule says that the doctor shall take any medical records that they give them for review. So that's why I gave you all this information, because I think it's important. If you are hearing that, you now have the rule that you can cite. And the other thing is, if they need to refer you out in order to give you an assessment, if the designated doctor needs to refer you out, for instance, if it is a chiro and we're dealing with herniations or we're dealing with something major, right, that they don't deal with, they have a right to refer you to a specialty doctor for further testing in order for that designated doctor to be able to give you an opinion. So, and it doesn't require pre-auth. So that's another thing you hear. It does not require pre-auth. They can refer you in order for them to give an assessment. In other words, if I cannot tell you, if I cannot give you an assessment because I need this test, they can do that, and it does not require pre-auth or anything like that. So another thing is, and this kind of goes in spurts, if the designated doctor, if they sent the injured employee for MMI and impairment rating, and within the review of medical records, the DD assessment it comes about from various things. Number one, physical examination, subjectively what they hear come out of the injured employee's mouth, and objectively what they see in the records objectively found. And then a review of all the medical records that they have from the date of injury up to, close to the time of the exam. That is how they arrive with an assessment. So if they're doing that and they're sent for MMI and impairment rating, and within the review of the medical and the physical exam and the subjectives and all this and that, and they see that there could be a potential extent of injury issue, they have the authority to be able to give multiple certifications. We see this happen sometimes, not sometimes. It is important because when they do that, they give you two opinions. They give you the opinion for the compensable injury. So they tell you for the lumbar sprain strain, I think this person's at MMI, August the 1st, 2017, with a 5%. So, and I use 5% because they go by criterias. So if I'm going to assert that he has herniations, radiculopathy, that sort of thing, and that's the extent, so that they would give a second opinion. And usually it's, I don't believe that he's at MMI. I give you an estimate date of January of 2019. And so we have two opinions now. Now we have one for the compensable injury and we have one to include the extent. That's an advantage for the injured employee because you have two. You have one taken into account for each situation. It doesn't take away that if they're placed at MMI and they give them an impairment rating, they have to dispute it within 90 days, because if not, then that one's going to become final. So that's a part under D. If they're requesting MMI impairment rating, and if they do ask for extent of injury as well, they have to provide what we call a DWC 68. So they'll provide a DWC 69, which shows the MMI and impairment rating, the doctor's name, the doctor's role, the certification date, the examination date, and then they'll do a DWC 68, which explains what they found to be compensable. So it'll have what they accepted on the top. On the bottom, it'll have the conditions that the carrier is saying is not related. Then they would say, yes, it is related, or no, it's not related. So we're going to move on to third page. It's 127.220. This talks about the requirements of the doctor in regard to the reports, which is a 69 and 68. And then 127.10, I think the medical people will probably get more benefit of this page. It just talks about billing and that sort of thing. The general procedures on that for the examinations, the report, and then reimbursement for medical documentation for the provider. So now we're going to get into the 32, the DD information. At the bottom, it starts page 28 to going into 29. It talks about the selection. All these areas here talks about the selection of the designated doctor. And usually when a designated doctor is assigned, that doctor would be the doctor for the lifetime of the claim, unless that doctor is no longer licensed or is no longer, has pulled himself out of the list of examining for the Dish and AMA guides. So on the 32, let me go to the, we're going to the page where it says completing DWC 32 and important areas of the form. It has the little picture like this. So page 2, this is one of the most common errors that we see. Under number 35, one of the most common errors we see is that they only check what's been accepted as being compensable. That is not what this box is for. Go ahead.
Which packet are you in?
The one that had the little doctor in the front of it. It's second to the last page. This box is made, the purpose of this box is to, if the injured employee tells you that every part of his body was injured, then you check every part of the body that was injured. If he tells you that the doctor said he has radiculopathy, then you check the nerve indication on it. This is a great opportunity for that doctor. If this is not completed correctly, you're going to get a report based on how well you complete this form. That's the easiest way as I could put it. But 35 is super, super important. If they tell you everything in their body hurts, everything got hurt at the time of the injury, mark it off. Let the doctor determine it once he gets it and he has the physical exam, subjective, objective, and all the things that he's going to do. So that one is super, super important. That's block 35, page 2.
If I remember correctly, box 35 is also part of what the division uses to determine the type of designated doctor that gets assigned.
Correct. See, she's a good student.
Yes.
Yes, this is where that golden answer to that question is, right? How do you select the doctor? It's right here. It's determined on what you check off. The matrix. So it's so important. Block 36 on page 3. That's also important for many reasons, but for MMI, impairment and extent of injury, that's one example, because it's you telling the doctor, what do I want of this exam, basically. So I want you to tell me, has the injured employee reached maximum medical improvement? Is there, can you address extent of injury? Because that authorizes the doctor to give multiple certifications. And the reason that's important is because if you don't put it in there and he only addresses MMI and impairment rating, and let's say he does address extent, the presumption is only held on MMI and impairment rating because he wasn't asked to address extent of injury. He saw it was an issue. He has authority to address it, but it's not going to hold the presumption, the preponderance of the evidence, basically. So that is a good opportunity, you telling the doctor, what do I want from this exam? That's block 36, page 3. And block 41 is important too. page 3, because if they've been to the designated doctor and the doctor said not an MMI, estimate date March of 2018, and in February that injured employee had surgery, that's where you would put that in there, 41, because there's been a change in his condition, something severely happened. Another example would be, we didn't have a radiology, now we have a radiology that shows different findings. So his condition changed. It changed from a sprain to a herniation, or whatever the case. It changed from a sprained shoulder to a rotator cuff tear, whatever the case may be. 41 is important for that as well. So we'll move on to block 42. So this is important on block C, the extent of injury, because you have to be very descriptive on the mechanism of injury. This is another area that we see that's very weak, is there's not much description in there. So you're going to get what you put into it. If you put slip and fall, hurt right shoulder, that's probably kind of the report you're going to get back, because that's what I would think. How bad is that? Was there an impact? You know, was the floor wet? Did he hit his head? I mean, there's so many things. So important. Be very descriptive in the mechanism of injury. And under list all injuries, here is where now we're going to go to the last page. Or behind it, it has another little doctor. So here are some helpful tips and examples of how I complete my 32s and how I have found it to be very successful in the report. So block 42 under C for extent of injury, if it's just an extent of injury issue, just plain old extent of injury issue, the question that I usually put in there is the mechanism of injury described below for the compensable injury of, and then you're going to put the date of injury, and or its effects a producing cause of damage or harm to the structure of the claimant's current condition of. There you put the condition of the diagnosis, and then you put the body part. Please explain in as much detail as possible. So they're going to really rely on that mechanism of injury when they're making a determination of the question that you want answered. If we're dealing with a pre-existing condition, degenerative condition, or something that was aggravated, I changed the question up some. Is the mechanism of injury described below for the compensable injury of and or its effects a producing cause of damage or harm to the structure of the claimant's body to include current condition and degenerative changes of, and then you're going to put the degenerative changes in the left knee, put the body part. If so, did the injury of and or its effects enhance, accelerate, aggravate, or worsen any of these pre-existing conditions? Please explain in as much detail as possible. Moving on to the next one, I don't know if y'all deal with this, but new versus continuation. Do y'all deal with that? Okay, so here's a helpful wording for that. We would like clarification on the question if Mr. or Mrs. is suffering from reoccurring symptoms from a natural progression of the old injury of, let's just say January 1st, 2015, or whether he or she is suffering from new symptoms stemming from a new injury of January 1st, 2018. In other words, is the claimant merely having continuing symptoms from a pre-existing, and you put the body part and condition of the date of injury of so-and-so, or does he or she have a new, again, body part conditions, injury because of a re-injury on, and then you're going to put the most current injury. So you're asking him to tell you, is this new or continuation? So if you're not that detailed in the question, then you're probably going to get a not that detailed answer. Just look at it that way. The last page, it talks about extended injury whenever the carrier has paid for services. This is where I was telling y'all earlier. They'll say, well, they paid for surgery, so that means they accepted it. Well, they haven't accepted it. if it's an extent and that's a condition, they haven't accepted it. But we can use words other than accepted. So here you would put carrier accepted liability for surgery with a diagnosis of, and you'll put whatever it was, is the mechanism of injury described below for the compensable injury, you put the date of injury, and or its effects of producing cause of damage or harm to the structure of the claimant's body to include the current condition of, and you'll put that condition there, that the carrier accepted liability on. Please explain in as much detail as possible. So you're basically saying they paid for the surgery, you know, is it part of the compensable injury, yes or no? Let the DD address it. The next one would be based on a peer review. Do y'all see much of those? Well, we sent them to a peer doctor, and the peer doctor said that's not necessary anymore. Well, nowhere in workers' comp or anything, nobody can address medical necessity. Nobody can say, we have to go through the process, the pre-auth, you know, that sort of thing. But we can't even have a doctor tell us, is that, a DD say, is that medically necessary? So in that case, you could pose a question, does the injured employee still suffer the effects of the compensable injury of, and you put the date of injury, and its diagnosis, and is a compensable injury of, and or its effects, a cause of the claimant's current condition of? So that's the way to get around, you know, if you run into that situation. So the very last one is a scenario where the injured employee has either reached statutory MMI and there's a decision in order, because they'll go through the process, MMI, impairment rate, and extent of injury, and when it's found to be part of the injury, that gives them a right to go back to the designated doctor to get MMI and impairment rating based on what they found to be compensable. In other words, they get to add that condition. They get to make an assessment. So you would attach as the PLN 11 if it's through an agreement, because we can also get agreements through PLN 11s. I would much rather not. I would much rather do a 24 because it goes to the division, everybody signs it. But they also do PLN 11s where they revise them and say we've accepted X, Y, and Z. Or if it's a decision in order, you would put that information in there. And it was found that the compensable injury extends to and includes, and you would include those accepted conditions. And the claimant is requesting the DD be appointed to determine the proper MMI and impairment rating that includes the now compensable, and then you would put the diagnosis. So that's a scenario in case it goes through judicial review and it's been accepted.
On box 35, should the person completing the ability to list all of the body parts or diagnosis in boxes 37 and 42C, or is it one?
No, I think, well, 37, you can't really, you don't mess with that one. You're just going to put what the, 37, you're going to put what the insurance company is accepted to be compensable under number 37. 35, you said 35 in what other two boxes?
Yeah. Box 35, should that include everything that's identified in 37 and 42C?
That's why that's why they're going forward usually is because of the extent of injury, right? So just the easiest way to put it is 35 should have everything that they're telling you got hurt. So
Accepted
or not, yes. And that's where it's misconstrued. People think that they can only check what's been accepted. That's not what this box is for. It's check all the body parts and diagnoses that apply. It doesn't say check all body parts and diagnoses that are accepted, that apply. That means what is injured worker telling you? Head, neck, knee, foot, then it's head, neck, knee, foot. And then if they tell you more specifics like brain injuries or neurological, then you would check them off. Because the designated doctor is going to be told what the insurance company has accepted as being compensable. And he'll determine what he feels is compensable or not as a result of the injury. But
If the employee has a diagnosis of radiculopathy,
check it.
what box should they be checking? On the third?
It is going to be because they changed it up, but let me look. I think it's going to be under spinal cord injuries, including spinal fractures with documented neurological deficit. So it'd be spinal cord injuries.
Thank you.
So I think that's a highlight on these. And I didn't go over all the DD selections. I'll leave that up to y'all. That's homework for y'all. But it's very, very interesting. It's very good information from the division. It tells you how they're selected based on injuries and diagnosis. So if you look at page 30, selecting designated doctors, it looks like this. It'll tell you head and upper extremities, the license type, lower extremities, no feet, and gives you the license type. So that means any of those doctors who are licensed in the 4th edition AMA guides can be potentially selected to do that exam. Later on, wherever you don't see DC, DODC, where you just see MD, which let me go to that page. Like the psych evaluations and that sort of thing, I think that throws them out to where they don't.
So, am I understanding this right? A chiropractor can only be assigned if one of the first 4 boxes are checked in box
Pretty much.
35?
Yeah, pretty much.
Any of the other boxes are checked, it has to be somebody other than.
The matrix will shift up to a higher qualified doctor under that specialty.
So if we have an employee with the adjuster's accepting a lumbar strain, but the MRI is showing that there's a herniation, and the employee, where the doctor says there's radiating pain down their leg,
Mm-hmm.
that particular case would have multiple boxes checked outside of the first 4, so that case should not be assigned.
It's based on the matrix, but yeah, specifically on the DD selection, yeah, it throws them out. It takes the chiros out of that area depending on the complexity of the injury.
So that's page 30 and 31.
It starts, yeah. So as you can see, traumatic brain injury, there's no chiro in there. We would hope not, right? Spinal cord injuries, if you look at that, that's page 32 under slide 63. Again, there's no chiro there. Severe burns, including chemical burns, it's going to be a specialty doctor. So that's the easiest way to look at it. Basically anything past the first 4 boxes is probably not going to go to a chiro.
Thank you.
Mm-hmm.
That answers a lot of questions.
Yeah. So I think it just education and just going through them. I mean, people really don't realize that, but this really does determine the outcome of that report. And a lot of those areas, well, specifically the areas that we went over are the highlights of what that determination can be. It had to be detailed in the mechanics of the injury. And that concludes this, unless y'all have any questions.